Dorothy Calloway, 72, widow of 11 years, retired estate attorney, grandmother of 4, introduces Warren Hines, 62, to her family on a Sunday in October. She has been dating him for 7 months. He is handsome in the specific way of men who have cultivated their handsomeness as a professional asset. Practice smile, easy charm, the particular attentiveness of someone performing rather than feeling. Dorothy's daughter Linda, 48, notices this within 20 minutes and says nothing. Dorothy's son, Richard, 51, notices it within 40 and says something to Linda in the kitchen while they're doing dishes. Richard quietly, he's 10 years younger than her. Linda, I noticed. Richard, he keeps talking about her incredible life and her remarkable accomplishments. Linda, I noticed that too. Richard, no one talks about someone's accomplishments that much unless they're calculating the net worth attached to them. Linda dries a plate, looks out the kitchen window at Warren and Dorothy on the porch. Linda, should we say something? Richard, she's 72. She was an estate attorney for 40 years. I think she sees what we see. Dorothy finds Linda loading the dishwasher. She does not require her daughter to bring it up. Dorothy, you think he's after my money? Linda, Mom. Dorothy, it's a reasonable concern. He is 10 years younger. He has a modest income. History, he is very attentive. I would think the same thing in your position. Linda and Dorothy, and I am a retired estate attorney with 40 years of experience in asset protection. I have a prenuptial agreement drafted by Gloria Okafor, who has been my closest friend and legal colleague for 35 years, who took one look at Warren over dinner for months ago and said, I'm going to draft you something airtight. She was not being dramatic. She drafted it. Linda, you're going to marry him? Dorothy, I am going to enjoy my life on my terms. If that includes Warren for a period, the prenup ensures the period has a clean exit. If it does not include Warren, the prenup will have been a useful exercise for nothing. Either way, I am protected. Now help me with these glasses. Narrator, Warren Hines has a history that Dorothy's family pieces together over the following months to prior marriages, both ending in divorce. Both to women older and more financially established than himself. He has a pleasant personality and no apparent career trajectory. He describes himself as a consultant, which he has been intermittently in home renovation project management. His income is irregular. His lifestyle expectations are not. Richard hires a background check service and discovers nothing criminal. He shares what he finds with Dorothy. Dorothy, to prior divorces from women with money. Yes, I know. Richard, Mom, that's a pattern. Dorothy, I know what a pattern is. Richard, I also know what a prenup is. Bring me a concern I can't answer and I'll take it. More seriously, Richard does not have a concern she cannot answer. He lets it go. Dorothy, I want to tell you what I knew about Warren. I knew he was charming in a way that is indistinguishable from genuine. Unless you have spent 40 years reading people in legal contexts, I knew his attention was calibrated. I knew, because Gloria had run a quiet inquiry at my request, that his prior divorces had not yielded him what he had apparently expected. I was under no illusions about his motivations. I simply did not consider them my problem. That is the function of a well-drafted prenuptial agreement. It converts the other person's motivations into your problem only if you let it. I did not intend to. Gloria Okafor, 69, has practiced family and estate law for 38 years. She has drafted hundreds of prenuptial agreements. She knows the difference between a document that protects and a document that merely appears to protect. When Dorothy called her about Warren, Gloria had one reaction that she describes, without embarrassment, as follows. Gloria, I met him at dinner. He ordered for Dorothy without asking what she wanted. I went home and opened my laptop and started drafting. Gloried. The most common error in prenuptial agreements drafted by generalist attorneys is insufficient specificity, broad language that sounds protective but leaves interpretation to a court. My approach with Dorothy's agreement was the opposite, specific, exhaustive, and drafted with the assumption that every clause would be challenged by a motivated adversary. Because I had met Warren, and I knew he would be a motivated adversary eventually. She walks through her approach. First principle, define every asset with particularity. Not Dorothy's financial accounts but the specific account numbers, institutions, and current valuations, updated quarterly and annexed to the agreement. Second principle, close the income loophole. Many prenups protect premarital assets but leave marital income and money earned during the marriage subject to division. Gloria made Dorothy's income during the marriage explicitly separate property. Third principle, no alimony, no spousal support, no transitional assistance of any kind, under any circumstances, regardless of the duration of the marriage or the financial disparity at the time of dissolution. Fourth principle, property used by Warren during the marriage, vehicles, residence, credit facilities, to be held exclusively in Dorothy's name, with explicit language that use does not constitute gifting or create ownership interest. Fifth principle, independent counsel requirement, fully documented. Warren had his own attorney review the agreement before signing. This removes the duress and unconscionability arguments that invalidate prenups most commonly. Gloria, Warren's attorney, a generalist he found through a referral, reviewed the agreement. He advised Warren that the terms were aggressive, but legally sound. Warren could have walked away. He chose to sign. I think he signed because he calculated that the marriage would outlast the prenups. Relevance, that he would find a way to make it moot. That is a calculation I have seen before. It is always wrong when the other party has drafted with a professional who anticipated it. Warren signs. Dorothy signs. The agreement is witnessed, notarized, and filed. Gloria keeps a copy in her personal files, flagged. Gloria, I kept it flagged because I knew I would need it again. I just did not know when. The marriage was, in its first 6 months, not unhappy. Warren was attentive, domestically present, and socially functional. Dorothy was under no illusion that the attentiveness was love. She had been a practicing attorney for decades and was not susceptible to the confusion of attention with affection, but it was pleasant enough, and she had entered the arrangement with clear eyes. The second 6 months were different. Dorothy, I want to be precise about what changed, because imprecision is how these situations get dismissed as personality conflicts when they are something more specific than that. Warren began expressing opinions about my financial decisions, not requests, opinions stated as corrections. He felt I was too generous with my charitable giving. He felt my investment allocation was too conservative. He felt my relationship with my financial advisor was insufficiently leveraged. None of these opinions had been invited. He began accompanying me to appointments I had historically attended alone. Medical appointments, meetings with Richard and Linda, conversations with my accountant. He described this as support. I described it privately as monitoring. He made social commitments on my behalf without consulting me. He declined invitations on my behalf without telling me. He told a mutual acquaintance that I had become less sharp than I used to be. I learned this from the acquaintance. None of these things, individually, is actionable. Together, they constitute a recognizable pattern. I had seen it in clients for 40 years. I simply had not expected to be sitting inside it at 73. Warren approaches Dorothy with a business proposition. A friend is developing a property in a neighboring county and needs a silent investor. The amount required $1 for 100,000, the return projected, significant. Dorothy listens to the full presentation. Dorothy, send me the prospectus and I'll have my financial advisor review it. Warren, I thought we could decide together. The window is narrow. Dorothy, Warren, I have managed my finances for 40 years without a narrow window closing on me. Send me the prospectus. The prospectus arrives. Dorothy's financial advisor reviews it in 3 hours and calls her. Advisor, Dorothy, this is not a real development project. The entity doesn't have the permits it claims. The projected returns are fabricated. I don't know who Warren's friend is, but I would not invest $1 in this. Dorothy thanks him. She does not tell Warren what her advisor found. She simply declines the investment. Dorothy, that was the moment. Not because it was the worst thing he had done, but because it was the clearest. He had not been testing the financial waters. He had been attempting a specific extraction. I had the prenup and I had my financial advisor and I had 40 years of experience with exactly this kind of document. He had none of those things. I decided that evening that 2 years was sufficient, and the marriage was over. Dorothy, pull the file. We're done. Gloria, I've had it flagged for 18 months. Dorothy, I know you have. File in the morning. Gloria, with pleasure. How are you? Dorothy, I'm fine. I'm angry. The anger will pass. File in the morning. Gloria, filed. Warren was served divorce papers on a Thursday morning. He called his attorney, the same generalist who had reviewed the prenup before the marriage, within the hour. The attorney pulled the prenup. He read it again, this time not as a document Warren was considering signing, but as a document Warren had signed and was now subject to. The conversation between Warren and his attorney was, by the attorney's later account in sworn testimony, brief. Warren's attorney, Warren, I'm going to walk you through this carefully because I want you to understand exactly what you're looking at. Warren, she can't enforce all of it. There have to be grounds to challenge it. Warren's attorney, let me finish. Section 3, all premarital assets remain separate. Her house, her investment accounts, her retirement funds, all premarital. None of it is touchable. Warren, the income during the marriage. Warren's attorney, Section 4. All income during the marriage is explicitly her separate property. That clause is unusual. Her attorney knew what she was doing. It's airtight. Warren, alimony. 2 years of marriage, there has to be some transitional. Warren's attorney, Section 5. Irrevocable waiver of spousal maintenance under any and all circumstances. The language is absolute. I've seen prenups with softening clauses, hardship exceptions, minimum duration thresholds. This one has none. Warren, the car. I've been driving that car for 2 years. Warren's attorney, Section 6. Use of property during the marriage does not create ownership interest. The car is leased in her name. You have no claim to it. Warren is quiet. Warren, what I have a claim to. Warren's attorney, your personal clothing and any personal effects you brought into the marriage. That is the full extent of your entitlement under this agreement. A long silence. Warren, she set me up. Warren's attorney, she drafted a prenuptial agreement. You signed it, with independent legal counsel present. That is not being set up. That is a contract. Dorothy serves Warren with the notice to vacate within 30 days. She is not present when he leaves. She is at Linda's house, having lunch, because she saw no reason to make the exit more dramatic than necessary. Warren leaves with 4 bags of clothing and a toiletry case. The car, a leased BMW that had been provided for his use during the marriage, remains in the driveway. He arranges his own transportation. Gloria, I have handled divorces for 38 years. I have never drafted a more efficiently executed dissolution. Warren departed with what he arrived with, himself. That was the intended outcome. It was achieved. Dorothy and I had lunch to celebrate, and she ordered champagne, and she said something that I have been quoting to clients ever since. Dorothy, the purpose of a good prenup is not to punish. It is to make the exit cost the same regardless of how long the marriage lasts. He came in with nothing that was mine. He left with nothing that was mine. The math is exactly right. Warren, through his attorney, challenges the prenup on 3 grounds. Unconscionability. The terms were to one-sided, duress he claims he signed under pressure, and misrepresentation he claims he was not fully informed of the document's implications. Gloria receives the challenge with the equanimity of someone who anticipated it. Specifically, Gloria to Dorothy, he's claiming unconscionability. The agreement is aggressive but not unconscionable. Courts have upheld far more imbalanced agreements between sophisticated parties. He's claiming duress. He had independent counsel and 30 days to review. He's claiming misrepresentation. His own attorney's review notes, which we subpoenaed, show a thorough line-by-line discussion. All 3 grounds are going to fail. He knows they're going to fail. He's buying time and hoping we offer a settlement to avoid the legal cost. Dorothy, we're not settling. Gloria, I know. The hearing lasted for hours. Warren's attorney presented 3 arguments. Gloria demolished each of them with the particular efficiency of someone who had drafted the document being challenged and had therefore anticipated every attack vector in advance. The judge was, by the court reporter's later description, notably brief in her questions. Warren's attorney argues that the agreement is so one-sided as to be unconscionable, that no reasonable person would have signed it freely. Gloria responding, Your Honor, the agreement was reviewed by independent counsel, retained by Mr. Hines himself. Counsel's review notes, entered into evidence, reflect a thorough discussion of every clause. Mr. Hines is a 62-year-old adult with prior experience of marriage and divorce. The standard for unconscionability in this jurisdiction requires both procedural and substantive unconscionability. There is no procedural issue. He had counsel. He had time. He signed voluntarily. The agreement is aggressive, yes. Unconscionable, no. Courts in this state have upheld far more imbalanced agreements in comparable circumstances. The judge nods. Judge, next argument. Warren's attorney presents his duress argument. Warren felt pressured to sign because the wedding was imminent. Gloria, the agreement was presented to Mr. Hines 32 days before the wedding date. He retained counsel within 1 week of receiving it. Review notes show for separate meetings between Mr. Hines and his attorney over a period of 3 weeks. He signed 11 days before the wedding. 32 days is not duress. 32 days is adequate consideration. The wedding date was not a gun to his head, it was a date on a calendar. The misrepresentation argument. Warren claims he did not understand that the income during marriage clause meant his lifestyle during the marriage would not create any marital property claim. Gloria, review note, page 7, paragraph 3. In Mr. Hines's own attorney's handwriting, client advised that section 4 renders all marital income separate property of the earning spouse. Client acknowledges understanding. His own attorney wrote it down and Warren signed the review acknowledgement. He understood. The judge looks at Warren over her glasses. Judge, is there anything else? Warren's attorney, Your Honor, we would ask the court to consider the equities. Judge, the equities are governed by the signed agreement, which I find to be valid, enforceable, and binding. The prenuptial agreement stands. Mr. Hines's challenge is dismissed. Costs to the petitioner. The hearing ends. Warren's court costs and attorney fees for the failed challenge. $47,000. His own attorney fees for the divorce proceedings. An additional $18,000. He does not have $65,000. He has. It emerges very little of anything. The court order is public record. The judgment Prenup upheld, challenge dismissed with costs is searchable. To subsequent women Warren attempts to date over the following years find it within minutes of a basic background search. GLORIA, public records are a feature, not a bug. Dorothy did not pursue him. The record simply existed, accurately, where anyone who looked could find it. That is the correct outcome for a man who spent 2 years attempting to extract what did not belong to him and then spent more money trying to extract it legally. The record is honest. It says he tried, he failed, the court found against him. That is a complete and accurate sentence. Dorothy Calloway is, at last count, 87 years old. She has been to Portugal twice, Japan once, Scotland 3 times, and Morocco on a trip she describes as the finest 2 weeks of her life. She has seen the northern lights from a ship off the Norwegian coast. She attended her granddaughter's wedding in Tuscany. She has, in 15 years, done approximately everything she wanted to do and some things she had not known she wanted until she did them. She has not remarried. Dorothy's granddaughter Claire, 28, asks her for a family archive project whether she regrets the marriage to Warren. Dorothy considers the question with the same careful attention she applied to everything for 40 years of legal practice. Dorothy, regret is an imprecise word. Do I regret that Warren was what he was? I didn't choose that. It was his choice, not mine. Do I regret marrying him knowing what I suspected? No, because I married him on my terms, with my protections in place, and when it was time to leave, I left. The marriage cost me 2 years of mild inconvenience and approximately $80,000 in legal fees to exit. It cost Warren his narrative, his legal challenge, and whatever he had been planning on for his retirement. The asymmetry is satisfying, I admit. Claire, do you wish you'd never met him? Dorothy thinks about this. Dorothy, no, meeting him reminded me that I was still capable of being interested in someone. That was useful to know. It also gave Gloria the opportunity to draft what she still refers to as the finest prenuptial agreement of her career. She has framed the cover page. I have seen it in her office. Claire, what would you tell someone in a similar position? Dorothy, I would tell them 2 things. First, the prenup is not a pessimistic document. It is an honest one. It says, I enter this with clear eyes and I will exit it with my dignity intact, regardless of what happens. That is not a lack of faith in the relationship. It is a respect for reality. Second, choose your attorney the way you choose your surgeon. You want the one who has seen it go wrong and knows exactly what to do when it does. Gloria saw Warren in the first 20 minutes of meeting him. She drafted accordingly. That is worth more than any amount of romantic optimism. Warren Hines, 77, lives in a studio apartment in a city 3 hours from where he and Dorothy had lived. He works part-time at a gas station, not from necessity, exactly, but because a series of decisions over many years have left him without the retirement structure he had apparently planned to acquire through marriage. He has not remarried. The public court record has made that particular strategy considerably more difficult. Dorothy does not know these details and has not inquired. She has better things to pay attention to. Dorothy visits Gloria's office the year she turns 85. The framed cover page of the prenuptial agreement is on the wall behind Gloria's desk, as she had been told. She looks at it for a moment. Dorothy, you actually framed it. Gloria, I frame the ones that work perfectly. In 38 years, this is the one I'm most proud of, not because it was complicated, it wasn't. Because it was complete. Every angle, Covered, no settlement, no negotiation, no concession. He signed it, he violated the spirit of it for 2 years, he challenged it, he lost, and she walked away whole. That is the entire function of a prenuptial agreement executed correctly. It is a rare thing to see it work exactly as intended. Dorothy, I told you he would be a motivated adversary eventually. Gloria, you did. I drafted for a motivated adversary. That is the only way to draft. Dorothy looks at the framed document. Then she looks at her friend. Dorothy, I'm going to Morocco again in March. Gloria, I know. You sent me the itinerary. Dorothy, come this time. Gloria looks at the framed document, then at her calendar, then back at Dorothy. Gloria, I'll clear the week. Dorothy Calloway has never described the marriage to Warren as a mistake. She describes it as a data point, evidence that she was right about the prenup, right about Gloria, and right about her own capacity to manage her life on her own terms at 72. The northern lights were green and white and moved like something alive. She photographed them from the ship deck at 2 a.m. and sent the photo to her children. Richard called immediately. Linda cried a little. Both of them had, by then, long since stopped worrying about their mother's judgment. The prenup is framed in Gloria's office. Dorothy has a copy in her files, stamped enforced. She has not looked at it in years. She does not need to. It did its job. She has done hers. If this story found you, subscribe. Leave a comment. Did the prenup give you peace of mind or make you nervous? And what does Dorothy's final line mean to you? That she didn't regret the marriage because she controlled the exit. The exit is the document. Draft it first. We'll see you in the next one.